Hello? To bring somebody in that can talk a lot about some of the challenges in the legal space that he's experienced as it relates to starting up his own companies. And so he was the co-founder and CEO of Cladwell, has helped a number of different companies raise their first round of capital. And so there's our VC capital. And now he's our founder and CEO of JumpDocs. And so great resource. He does another talk that we could potentially bring on in the future, which is all about fundraising, that I would think might be valuable as well, or will definitely be valuable. But today's focus is really on the top tips to avoid unaffordable legal potholes. Blake, I'll let you introduce yourself further, just to make sure I did enough of a good introduction, but then also introduce Lindsay, and then turn things over to you all. If you have questions, just feel free to drop a note in the chat and say, "Hey, I've got a question," and then I'll moderate and make sure that we find the right stops to serve those up to Blake. Sound good?
Works for me. It's nice to meet all of you. Paul, I feel like you did that was a fine and thorough introduction. Anything else to add on that? After I sold Cladwell about 18 months ago, it was, by the way, it was not like this amazing exit. I'm not calling you from my yacht. I'm calling you beachfront on the Ohio River in Villa Hills, Kentucky, if that gives you an idea of the level of exit we're talking about here. And so, but after that, I had a little bit more time and I had a little bit more kind of capacity. And so because of that, I ended up meeting with a lot of founders. I made this video on YouTube. You can probably look it up. It was called 70 Lessons That I Learned in 7 years as a startup founder. And I kind of chronicled everything that I felt like I learned, almost as a little bit cathartic, but as a way of kind of just saying, this is everything that I've learned in these 7 years as a first-time founder. And at the end, I put my email address in and I said, hey, if you're a founder, you want to talk about fundraising, you want to talk about legal, you want to talk about partnerships, both with outside companies as well as the co-foundership, reach out to me. And that's resulted in now over 350 founder/CEO one-on-one meetings that I've had in the past year. It kind of blew up in a very small group of startup founders. And through that, I noticed some patterns among startup founders. Specifically, the biggest need they feel like they have is always fundraising. Like, how do I get the funding to accomplish the goal that I have? But the biggest mistake that they make is typically relational, structural, or legal, right? And often they make these early stage decisions that really make them snake bit and damage them in the long term, or become incredibly expensive or even relationally costly to remedy. And that was very frustrating to me. And the result of that is that I ended up starting this company, JumpDocs, to help mitigate that. And so what JumpDocs does is we partner with venture-focused law firms to help essentially these very specific startup-focused law firms scale their practice while not losing that personal touch. So essentially you get all of the affordability and speed of like a DIY service, but with the actual firepower of a real lawyer who knows the context and relationships necessary to know when to do something custom. And so Thompson Hine was kind of our pilot program partner in that. And I've learned a ton through Thompson Hine. They've been my personal law firm from a Cladwell standpoint, also for JumpDocs, for now getting close to a decade. And so I'm a huge fan of this firm because they have a very specific practice with multiple partners that focus specifically on startups. And I'd say, with that, I'll introduce Lindsay. What I love about Lindsay is that really there are 3 categories that we're talking about today, right? 3 parties. We have the party of the venture-backed startup, or the startup. 2, we also have the lawyer. And then 3, we also have the venture capitalist, which at the end of the day, what their preferences are tend to dictate how the lawyer and the startup will behave, because that's kind of, they're going to put the money in that's actually going to fund the business. And what Lindsay represents is actually both of those parties, right? So she's a VC, and in your past, you've actually been a VC partner, started multiple kind of investment companies, but then also you're a startup focused lawyer. And so we got two for the price of one today, which is just great. And so I'm really excited to kind of have her. She's obviously a partner that focuses specifically on early stage startups in the state of Ohio for Thompson Hine. Lindsay, can you fill in any other details that I missed in that?
Yeah, you did a great job. So for 15 or so years, I was not only the chief legal counsel for a family of venture funds in Ohio, but then also fought and scratched and clawed my way up to be one of the managing partners there. The reason I'm a partner at Thompson Hine is because I accidentally started a law firm in 2010. And I was just helping clients what I thought was do the right thing, because there wasn't really actually anyone focused in Columbus on doing startup work. And so I saw a need and I saw an opportunity. So I just started helping people onesie, twosie. And then before you knew it, I had like 200 plus clients. And so I was representing venture funds and startups and small businesses and all of that, not just in Ohio, but that state up north we don't really talk about. And then in New York, and now my practice spans coast to coast. But Thompson Hine started kicking the tires about 2.5 years, well, 3.5 years ago, I guess. Now I always skip over last year like it didn't really happen. But about 3.5 years ago, because when you can't beat them, you buy them. And so they ended up buying my practice 2 weeks or so before the world fell apart in 2020. So that was an interesting experience. But now I'm still general partner in like 6 venture funds, and actually helped run and launch one of the most active seed funds in the country in New York. So that was really awesome. I did that for about 4 years also. But now I play full-time law firm partner, and I sit within the emerging companies practice group, but then I also oversee all of fund formation. So the reason that that's important to you is because I, yes, represent hundreds of startups. And so I know the pain points that they have. And then on the flip side, I represent hundreds of venture funds and investors. And so I also know what it is that they're looking for. So I can close that gap really quickly and easily for folks. And if we're not on mute, just make sure that we're on mute if we're not talking, so that it's not distracting for everyone.
All right, cool. Well, with that, let's kick this puppy off. I'll share my screen, and we've got a top 10 list for you all here. So Lindsay and I have put together, kind of collaborated before all of this to say, okay, if we could just leave you with 10 legal mistakes that founders keep making over and over again that they really can't afford to make. And so these are kind of based both on frequency and severity of if you get this wrong. And so what we're going to do, we're just going to kind of like a top 10, start at number 10, work our way down to number 1. And Lindsay and I will just kind of tag team knocking this out, and we'll have hopefully plenty of time for questions after it. Or if it feels really relevant of like, hey, please clarify that, just drop it in the chat, and that would be great. Cool. And then Gabe, would you mind muting real quick? We could hear when things shift on your screen, or maybe Paul, you can mute him as well. Then we should be good. Cool. All right. So without further ado, welcome to the top 10 legal mistakes founders can't afford to make. So I'll kick us off with the number 10, the mistake that, and by the way, let's just see how many of these mistakes I made in my last company. I may be in the B plus A minus range in terms of how many, I guess it'd be the inverse of that. It's literally, I've made almost all of these mistakes myself. So that's how you learn sometimes. So starting off, all right, number 10, I would say one of the big mistakes that we see is founders who delay forming a Delaware C Corp. And I'd say this kind of takes 2 forms that I've noticed. The more common one in the Midwest is we actually will say, oh man, it's $200 to form a C Corp, and it's only $70 to form an LLC. I guess I'll form the LLC. And what ends up happening is, and that's actually there from a tax standpoint, if you talk with an accountant, there are a lot of valid reasons to do an LLC instead of a C Corp that I won't necessarily cover here. But the big thing is if you have losses as a company, you as the founder actually are going to get to take those losses on your tax statement. So essentially, you might not have to pay taxes for a couple of years, which is pretty cool, and you can actually accumulate those over time. But the reason you'd want to do a Delaware C Corp, which is that those losses all will stay within the company. Everything from a tax standpoint stays within the company with a Delaware C Corp. And the reason you would do that is because VCs, they don't want to have to deal with your taxes. And so they will actually require, typically when they write a check, they'll say you have to be a Delaware C Corp because we don't have to deal with a K1 that comes from your LLC. We don't want to be a partner in your LLC. We want to be an investor in your Delaware C Corp. And so I would say the delineation that I would say, if you're kind of on the fence as to whether you should be an LLC or a C Corp, it's if you intend to take on venture capital, then you should be intending to take on venture capital really in the next year. That should be year to 18 months is kind of the target if you're on the VC track. Therefore, you should really just start as a Delaware C Corp. If you're not sure if you're going to take on venture capital, then it's a longer conversation to maybe talk with your accountant about what kind of makes more sense. But the mistake that I see more in the Bay Area is actually delaying forming an entity at all. Okay, so it's like it's not even that they chose LLC and then switched to Delaware C Corp, is that they're just like, you know what, we'll deal with that later. We're just a bunch of friends. We're building something together. It's okay. We can deal with the legal structure stuff maybe once we get a check. But the problem is that there are a couple big events, maybe two big events that happen that I've noticed that happen sooner than you expect. One is you make something of value, right? There's some level of intellectual property, and suddenly there's no container that you're putting that value into. Instead, it gets really muddy about, well, who owns this idea? Who owns this new concept? And maybe one co-founder thinks, well, I've made most of the idea, so 80% of it belongs to me. Another one's like, oh, but I'm the one who's been executing all of it. So the forming the entity actually forces those conversations early and sets up a structure so that you don't have really relationally difficult conversations. Number two would be obviously from an investment standpoint or a revenue standpoint, you really want to actually start collecting all of that in the bucket that is specific to the business, as opposed to putting that in your own personal bank account or some previous entity that you had. And so I'd say that's the number 10 mistake that I've seen time and time again in the past year. I've seen that a lot. Lindsay, would you weigh in on that? Any other elements that you would highlight in that?
Yeah, so I think sometimes, just to dig in on your one point about cost, I get it. Cash is king when you're starting your business, but don't be penny wise and dollar foolish moving forward. So, oftentimes it's very, very costly to do a conversion if you started as a Delaware, because a lot of people go, well, Delaware LLC and I'll just convert to a C Corp if I need to, or they start as an Ohio LLC and they convert later. And that's fine. But, if you've got 5 or 6 years of operating history and you've got 40 members and they've all got profits, interests, and all sorts of other chaos that's happening in your corporate structure, and then you go to convert it, you can be looking at a bill of $40, $50, $60, $100,000 to make that be so. And so, I just can't stress enough how significant that can be. So if you do think, hey, I'm going to take on VC funding, you really do. I really would just say, just form the Delaware C Corp up front. If you get 2 years down the road and you're like, I'm never doing this, you can convert out of that and become an Ohio LLC if that's something that you wanted to do, because you're not going to become a venture-backed business, and that is a-okay too. All of these are fine. It's just, let's try to set you up for success. So I think that is the primary issue. I would say my VC folks, they don't want to deal with your unintended business income tax issues. So I know you're probably going, well, why do they mandate it? And, Blake dug into that, but they actually are contractually obligated by their investors to not invest in LLCs. So if you think you're going to be backed by these folks, do it the right way up front the first time. It just makes your life easier. Yes.
One more comment is that if it's a startup focused law firm, typically they have an incredibly affordable package for this.
Yeah.
Sometimes they'll defer, other times they'll comp, otherwise they'll greatly, for you guys, you take a loss. I've done the analysis and you guys take a loss on this because they work with these startups in the long term. So if you get a quote for $10,000 for the formation,
Wrong.
you're working with the wrong lawyer.
Yes.
And so talk to somebody like Lindsay, who actually, I mean, this is not something that breaks the bank.
No, it's not. And oftentimes, like, companies are just, so, I could talk about Jump Docs here for a hot second too. I mean, Jump Docs, they're just charging you basically a subscription fee, which is ultimately less than you would pay if you're going to engage a lawyer and then pay the filing fees and do all those things. And you get all sorts of other perks with that too. I mean, but most firms are just charging you the filing, if they know what they're doing, are just charging you the filing fees that they paid on your behalf. So, just make sure that you're talking to the right folks. And anyone who's saying, like, we'll get into this one too, I think, but anyone who says, like, oh, I'm a corporate lawyer and sometimes I do startups, like, run away, because that's not who you should be talking to here. Yes. So cool. Any questions on that before we march forward? Cool. So okay, next. So there can only be one. What are we talking about here? Not having a tiebreaker. So, okay, let's say that maybe you are an LLC or you're a, C Corp, doesn't matter, but your decision-making authority ultimately sits in the hands of 2 people or 3 people, all of which have exactly the same, voting authority, but, or maybe all of them have blocks. But let's look at it in the instance where we only have 2 people who have decision-making authority and they both have equal rights and equal voting percentages. I hate to break it to you, but it's not always going to be unicorns and rainbows, and you're not always going to agree on everything. If you always agree on everything, you probably don't need both of you. Okay, so let's think about that. And then let's say, okay, well, we need to have some sort of tie-breaking mechanism. Because if you do stalemate on a topic and you've got a company and you can't move the ball forward, and now you can't spend money or take on investment or purchase equipment or do whatever you need to do with your business, and you're sitting in a stalemate for years, you are ultimately going to kill your business and end up in a judicial dissolution more often than not. And so let me just walk you through how much a judicial dissolution costs. I've got one pending right now that's sitting in now arbitration, it's been moved to, but that has cost $110,000 to date. And it is not like a thing that I'm excited about for these people, because the one person really wants to break up, the other person doesn't, no one can get anything done. It's a real hot mess. So, this is a real thing that I do see. And so I just want you to come up with mechanisms for which you can break ties. So maybe if you have an issue where you need a tiebreaker, you have a third party. So you have 3 decision makers. Maybe you engage an advisory board and the advisory board makes a recommendation and you have to agree with that decision of the advisory board. Things I wouldn't always agree with doing, but I have seen flipping a coin. And the coin that lands on whatever, is the decision that gets made. I have seen it, wouldn't advise it, but it still keeps the ball moving forward. So Blake, I'll let you chime in here. And if you have anything to add to that, please go ahead and let us know.
Yeah, no, the only other thing I would say is in terms of tallying these, on the first one, I was one of those companies that paid $90,000 to convert from LLC to C Corp. That was the bill, was $90,000, and that was after a discount. So it would have been a lot more after that. So that's one. Number 2, I started off with co-CEOs. How do you like that for a startup? We thought, you know what, is me and my best friend, and we thought we could totally do this as co-CEOs of our startup with Cladwell. And guess what? That didn't work. And I think it kind of goes back to if you don't have a tiebreaker and everything you have to mutually just agree to, you're actually committing to making every decision twice as slow. And so I'd say just for the survival of your business, clear hierarchy in terms of who makes decisions and having the ability to quickly disagree and commit will make you a much healthier and faster moving organization. And you need to look no further than any primate. Like all primates typically have the same structure where there is one at the top. And that's there for a reason, right? Like it's like that's how they survived and that's how we've survived. And so I'd say if you're bucking nature by trying to say we're going to just always agree together, I think that you're betting on something that you're tackling not only market risk, but now like organization risk, which is like why take on more risk than you need to. So that was my only other point. But cool. Any questions on that? Comments on that, Paul? Yes.
I have a quick comment. Yeah, just to further this one even more, right? When I spent time in P&G Ventures and at Gallo, you might say, hey, big company might not apply, but we were creating innovative companies within our company. And oftentimes they were not just amongst partners internally, they were with companies outside. And this was a key one that we always made sure we built into any organizational structure, because there had to be some level of like decision-making authority for the exact reasons that you said, right? Like, frankly, mainly speed to market, but also just control, right? Like, where was the control going to be to make sure that the value of the entity was then fully created? So anyway, love it.
Thank you, Paul. That's great. Cool. All right. So number 8. Okay. Giving too much equity too early to employees. And I think it's probably important here to distinguish between co-founders and employees. I would say that a co-founder has to meet a couple criteria. One of which is they have to be a subject matter expert on a core competency of the business. So if you need to have a sales leader and the business is based on sales, like, okay, you could have a sales-based co-founder or a technical leader in a technology-based business, right? Like, they need to be someone who's going to be commit and stay with the business for a decade at least, right? That's a co-founder. I'd say typically with a co-founder, it's okay in my book to say how much equity, try to give as much equity as possible to a co-founder, because that's going to incentivize them to work harder and grow the business more. A founding employee is someone who maybe isn't here for the long term, but has expertise that's useful to the business right now. And the philosophy that I think it makes the most sense is hire few employees, pay them as much cash as you can, and give them as little equity as kind of the market dictates. And I think that a lot of founders will say, I'm going to get as many employees as possible, pay them as little as I can, and then compensate them with equity instead. And that kind of double compounds this problem of giving too much equity away to those early employees. And what happens is after 2 years, they get an offer. In my instance, one of my early employees got an offer from Beats Audio before they got bought by Apple. They tripled the salary that I was paying him. He didn't have vesting on his equity. And so after a year, he left and took a quarter of the company with him. And so that sucked. And so guess what? I went back to him. I said, hey, man, I just feel like, we gave you this equity and we expected that you were going to be with us for a long time. We think it would be fair if you gave back some of the equity of the company. And you think he did it? No fucking way. Of course he didn't do that. He held on to it. And of course he had all these justifications in his mind. But at the end of the day, he had no reason to give it back. And so we lost a quarter of the company in the first year, just like that. Because really, we thought that we were motivating this early employee. But in reality, what we should have done is paid him $10,000 a year more and given him, not even that amount of equity, and made sure that it vested over the course of 4 years. But live and learn. Right now, we're 3 for 3 on mistakes I've made. Lindsay, anything else to weigh in here? I'm sure you see this a lot.
Oh yeah, I see this all the time, because again, cash is king when you're running your business. So you're thinking to yourself, oh, well, if I give away some equity, I'm not really like feeling that pain. And this goes along the lines of a couple other things that we'll talk about today, but the earliest equity and the earliest investment that you give away is your most expensive equity. Okay, so because it's going to ultimately likely generate the most value, but there's usually a lot of risk. But I think that you just need to be so careful when you're doing this, because the pie is only 100%, right? And so if you've got people who run away with 25%, now you're really working with a pie of 75%, and that's got to come out of someone's hide. And guess whose hide it doesn't come out of? The investors. So that means it has to come from somewhere, which means it has to come from the team. And so you need to keep your team and yourselves appropriately incented funding if you're going to take on investment capital, because this is a long, hard slog when you are an entrepreneur, and you need to know what it is that you are going to be walking away with at the end of the day, or at least your goal. And if that is a very minute percentage, for years and, a lot of stress and maybe not seeing your family and all those things in your life, it starts to become not worth it, right? So you need to make sure that it's worth it for you. Every time that you give away equity, you should run what we call your waterfall. So waterfall means, how does the money flow out? So at the end of the day, you know what you're walking away with. If you got $10 million into your business right now and you're going to liquidate it, every time you're going to give away equity, you should think about, as a founder or a CEO or whatever, how does this impact my bottom line? And that's not being selfish. You need to know if you care enough to move this down the line, right? And you need to know, is this person valuable enough to give them 4%, 5%, 20% of the equity over time? So all good stuff there. Any questions before we go on to the next one?
Yeah, Chris, go ahead and shoot your question.
Yeah.
So my question is in regards to something called virtual equity. And so what we've kind of told our employees is that, we won't actually change like our operating agreement to add them as having actually shares. But, in the case of where, there was a buyout, that they would actually receive a portion of that. And so we haven't really wrapped that around, like a percentage or definition or anything like that. So we haven't gotten to that point. But my question really is this, is that, are there any like legalities in that? Like, is there certain guidelines when we talk about, creating a virtual ownership agreement? Has anybody ever done that? Is there something, I guess, what I should be thinking of that would actually be a concern for me legally?
Yeah, so what you're really talking about here is the equivalent of phantom equity. Okay, so that's normally what we would call something like this.
Mm-hmm.
It is tied to oftentimes profits of business, certain sale prices might be a trigger, things of that nature. Things you kind of need to be careful about here. One, this does need to be documented at some point in time, because you are now making promises to people upon which they are now relying, and nothing will set you up for an employee lawsuit upon your great success, quite like not making a bunch of promises, them not getting written down, maybe there's some email trails, and then all of a sudden, you've got a big headache and a big problem. I think the other thing to be conscious and cognizant of here is, this is not a great plan for employees, because from a tax perspective, they are not getting the benefit of riding this for 12 months or greater, meaning they're not holding equity in your company for 12 months or greater, meaning at the exit, they are paying ordinary income tax on the entirety of what you would be sending to them, as if likely it also could arguably be treated as a bonus, which means it's taxed at an even higher rate. So, I think a couple things there. If you are an LLC, things you can think about, you can create profit interest plans. And so those are built on trigger price points, like they're only in the money over a certain valuation, which incents all the team members to say, hey, if I grow this to $25 million, I get anything, I get to participate in a percentage over $15 million, if that's where your trigger price is. Okay. The other thing is, you technically can build an option pool with LLCs. It's a little more complicated, but you can do it. And so the option plan gives your folks the feel of maybe owning something in your business, but they don't really have a voting right in your business. They're just getting a percentage of that equity, and they can exercise it, which means they could hold for greater than 12 months, which means they could benefit from the capital gains treatment in the future. So long-winded way of me saying, I have had clients that have said, no, this is the way I want to do it. It's based on a sale price. And that can get really complicated, because if you get your sale price and you only get part of it, and then there's a holdback, like who's managing the second tranche of money? How are you getting it to those people? So some of the things I would just think about there would be making sure that you write it down, everyone knows what they're getting. And if you could do it in a tax beneficial way for you and the folks on your team, that's usually a good result. So Blake, I don't know if you have anything to add there.
No, I think you got it.
Thank you very much. Appreciate that.
Great.
Cool. Lindsay, you want to take this one?
Every time a startup goes under, an angel gets its wings. And so what does that mean? That means sometimes we are going to go ahead and we are going to take on angel investors. So those are early investors, and they're taking a big flyer on us, and they are undertaking a lot of risk. A lot of times their check sizes aren't super big, but maybe you need that money. Number one, maybe they have some connectivity. They can help you, in an advisory capacity. They can do some other things for you. But what I see a lot of times is people get so excited. They're like, oh my goodness, someone wants to give me money. They believe in my dream too. Okay, here we go. And they take it on at these terms that just don't make any sense. Okay. And so what we need to do is we need to make sure that we're contacting folks, be it our accountant, our lawyers, our other people who've done this before, like Blake, and say, would you do this? Would you do this deal? And really figure out if the economics of these terms make sense. And it's not just the economics. Okay. So I always talk about money, power, respect being the key to deals, but money, yes, that's important. These economic terms are important. Are you giving away 40% of your company for $10,000? Don't do that. That is a dumb move. I would say if you're going to think about how much money to give away in your early rounds, it's your most expensive money, reminder. So make sure we're thinking about that. This is, somewhere in the, if you can get away with a lower percentage, 10 to 20% of, your company for this first angel round. Awesome. You start to creep up over that. That's going to be really painful down the line. Okay. So you've really got to think about that in terms of economics. The other thing we see is power, so control. Sometimes you get these angel investors in there and they woke up and they said, I'm going to be an angel investor today. And you're like, okay, that's neat. And then what happens is they also don't understand what they're doing. And so they want to come in and they want a board seat and they want to opine on everything that they do. And they want to talk to you once a week and understand how much their investment is worth now. That is not what you need to be signing up for, right? You need to be signing up for, yes, dollars, but you need to be signing up for people who are going to add value beyond the dollars that they bring to your table. And you need to make sure, for lack of a better phrase, that they are not going to be a pain in your ass as you're trying to grow your business and they're wanting to know, why did you spend $12 on a roll of toilet paper or pack of toilet paper, right? Like these are not the people you need to be bringing in. So, you need to have all of those things sort of thought about as you're thinking about bringing on these angel investors, because if you just bring on the wrong folks, especially if you put them on your board and they are just a pain in the bum, it actually can deter future investment. I've seen this happen where you've got just some pain in the ass board member who just keeps being an idiot. And every time they open their fat mouth, they destroy an opportunity to take on future investment dollars. And so I've seen companies actually not be able to get really great investment from really important VC folks, like from the Bay Area, because one board member who is a dum-dum wouldn't shut their mouths. So anyway, I'm going to turn it to Blake here to see if he wants to add anything to that.
Yeah. Yep. You've articulated the problem well. I'd say two things you can do as a founder to avoid bad investment term sheets. Number one, you have to pitch a lot of people. So my rule of thumb with angel investment is for every $10,000 you want to raise, you need to pitch one investor, right? So if you're raising, call it $500,000, you need to talk to at least 50 investors. If you do that, then you're far less likely to get someone who comes with a $25K check and requires the board seat or something like that, because you have optionality. So then you can push back on some of those terms. So that's number one. Widen that funnel. The more people you pitch, the better. Number two is reach out to a founder who has raised venture capital before. Not just has raised angel money before, but has actually raised venture capital. I'm one of those founders. And I review literally in my texts right now. I have someone who's sending over terms to me today, this morning, of saying like, hey, is this a good deal? That's a very easy thing for me to answer very briefly. I'm not a lawyer, but I can say from my standpoint, this is how that compares. I would say specifically in the Midwest and especially in the South, there are some angel investors who don't know how the term sheets that they give affect VCs later on and at what they're viewed as. And in the Bay Area, they actually recognize the pattern. And so if you come from the Midwest with a bunch of angel investors, their assumption is going to be that's a lot of drama. That will be their assumption. And so you need to prove those VCs wrong by in paper saying, actually, no, this isn't a lot of drama. This is a very clean deal. We used a safe, or we used a very clean NVCA convertible note. This is very straightforward. But otherwise, you're guilty until proven innocent. And I had this problem. I had 50 angel investors who'd invested 1.2 million on my cap table. So 50 people on like 7 different convertible notes on a cap table that was managed in Excel. And I brought that to a VC in Los Angeles. I was in my final due diligence with 4 partners, 2 of whom were ex-CIA. So it was really intense. It's a 4-hour meeting. And at the end, they looked at my data room and they said, Blake, just to be clear, if you hadn't shown us this cap table, you would have an investment today for $1.5 million. But because of what you just shown me, we will not be moving forward with your business. That's a direct quote. I lost the deal because of the fear of the angel investors. And you know what? They were right, because when I had to sell my company, those same angel investors made it incredibly difficult and prolonged that process, costing several $100,000 to the business just by delay. So this is a big deal. And this mistake is happening a lot. So email me or somebody, review it with your lawyer, but just get other people in the conversation, man. This is huge. Cool. All right, next up, number 6, messing up intellectual property ownership. Who owns the idea, right? And who owns this idea versus that idea, right? So there are 2 scenarios, one that I'll talk about and then maybe the other Lindsay will talk about. The big scenario here is one that I actually encountered, which was I had an intern who lived in my basement. And so he worked for rent. And then I got, 40 hours a week of internship from him for like 9 months. Already, this is a great structure, right? With my last startup. This is very early on. And at the end, we raised $300,000 in angel money, and his internship ended. And I said, all right, man, it was really great working with you. Have a great summer. And he's like, no, I think that I've really contributed here. This business, I mean, it wouldn't be the same without me. I think I own 10% of this business. And if you disagree with me, I'm willing to hire a lawyer and to press this. So he threatened to sue me while he was living in my basement. And the best part, which I loved, the best part was then he had the nerve to come up for dinner and eat a meal that my wife had prepared. And it was just like Cold War, like super tense around the dinner table. And we had a good old fashioned family fight, which was pretty amazing argument amongst all of us, which is pretty awesome. So the result of that is that the first check I ever made as a investor-backed startup was to pay off someone to convince them to sign an IP transfer agreement. And so that was the first check I ever made, is I paid that guy, I think it was like $10,000 to go away. And he signed it. And that was not a fun check to turn around and tell my investors how I started spending their money. You have to capture early on who owns this idea. And the answer is the company owns the idea. Everything that you're working on is owned by the company, which means you have to have that company in order for that to be the place. So that's the scenario that I made the mistake in. Lindsay, you wanted to talk about maybe in the instance where it's maybe a shared intellectual property, right? Yeah, that's a different scenario.
Yeah. So yeah, super important. Every time you bring someone on, make sure that they sign an IP assignment. That needs to include transfer of copyright, particularly if you are a tech business. If it does not say specifically copyright, you do not own the copyright. The other people do. Okay. And so copyright has to specifically be defined there in order for it to transfer over. So I just need to flag that because I see that happen a lot. Okay. Then sometimes we have multiple parties who own the IP. Maybe you have a joint development agreement because you're really great at A, other parties really great at B. Together, you will form one mega IP scenario where it's going to be so great. And that's wonderful. But as both of the parties are marching forward, you're each contributing to IP, you're making changes, improvements, and how do we decide that who owns this IP? And maybe it says you both do. Okay, that's great. But then we have to walk through, okay, what if one party wants to be purchased? Or what if one party wants to sell the IP to someone else? What results from other party who's still grinding away? like developing IP, so that's a problem. What happens if you decide that you don't like each other anymore? You know, how do you decide who gets what IP, who has what underlying rights? How do you officially break up? And so I will tell you right now, I have a very large financing pending, and one of the underlying issues is a joint ownership agreement related to intellectual property. I actually have this in 2 scenarios, and I will tell you one of these companies is $1 billion plus opportunity in the very near future, and they have a joint IP agreement with another party, and it causes nothing but problems in terms of trying to get these financings closed, trying to move them across the line. So you really, really need to be careful, because it can be the difference between you getting funding, not getting funding timely or not, or, you know, might limit your ability to get acquired at some point in time in the future. So make sure you're thinking about all those things. IP is a tricky space. This is a space where you need to engage someone who does IP work all the time. So licensing, joint IP ownership, those things, you really need to talk to someone who is hyper knowledgeable in that space, because you can really do some damage too if you don't appropriately allocate ownership and transfer capabilities and things like that. So any questions there before we march on?
I have a quick one.
Yes.
So it feels like there'd be 2 potential, but maybe even more, 2 potential types of like triggers or ways in which you would ensure that this is covered. If it's a co-founder, somebody that's working on the business as a co-founder of the business, would it be just written into effectively the bylaws, the governing bylaws of the actual entity? Or is there another vehicle? And then the second is, if you're working with kind of an outside vendor, it would then just be written into whatever the kind of scope of work that relates to like the vendor.
Yes. So second one first, typically, yes, you would see that the vendor would sign off on saying like, this is done as a work for hire. All of the ownership of the intellectual property is that of a purchaser or a person engaging the vendor. But again, that's one of those places where sometimes you get people who maybe aren't the most upstanding, and they kind of leave some pieces and parts out, copyright, copyleft, some of the source code, maybe some of the object code. Maybe they say, hey, they own all of the underlying IP and they're just licensing it to you. You need to understand what that is. You also need to have an understanding of whether or not they're using any open source code that's supporting what they're building for you, because that does become something that you have to disclose to your future investors. It's not a deal killer, but it can slow things down. You just need to make sure that you understand it and you understand who owns that code, what it's built on, all of that good stuff. Now, other side of it, co-founder. So technically you could write it into your, if you have like a shareholders agreement or something like that. I would say more typically what we do is we just produce a package that's like, okay, you know, we have our restricted stock agreements, because founders too should have those in case you have a co-founder who just runs off to Fiji with a third of your company. So you need to make sure their stock is vesting over time. We'll probably talk about that in a minute, but so you're going to have a document that says that. You're also going to have a document that's, you know, basically says, hey, all of the IP that they've created is owned by the company and they're transferring all the rights to that. That document typically also includes like non-competes, confidentiality, non-solicitation. So there's lots of things that we wrap into there, but that's typically where we would include that.
So that would then cover you for the co-founder and any potential employee.
Yeah. So basically they end up being the same doc. Like you don't need to make it harder than you need it.
Got it. Cool.
Great. Real quick check-in. Everybody, is this pace going okay? Are we circling too much? Everybody feel like engaged? Maybe turn your camera on real fast. Give me a thumbs up, thumbs down, like anything we can change. We're about halfway through the list. So I just want to make sure we're doing okay. Yeah, good. Yeah. Anthony likes it. I don't see anybody else's videos. Well, absent of any feedback, we'll keep on going. But please stop us if you feel like we're going too fast, too slow, anything like that. Lindsay, you had this next one, was talking about poor corporate governance. If you want to kind of kick that one off.
I'm on mute. So corporate governance, what is this all about? So we have these beautiful deal documents that we go through and we set out, how do we make decisions? How do we vote on things? How do we have approvals? And a lot of times we are operating in a fast and loose way because we're entrepreneurs. We got 1,000 things to do. We don't want to call our lawyer. That's expensive. And we don't write it down. And so we don't have board meetings and we don't do the other things that we need to do. And so in turn, we have what we call sloppy corporate governance. Maybe we haven't properly approved share issuances to employees, things of that nature. And so we have to make sure that we're appropriately documenting those and then saving them to our digital file room. Because one of the things that comes up when we go to do a transaction in the future is you have to represent and warrant that all of the issuances that you've done, all of these corporate actions have been appropriately taken. And if you can't prove that they've been appropriately taken, we make an assumption that they were not appropriately taken. And so that creates more paperwork, more cost, and slows the whole darn thing down. So Blake, I don't know if you have anything to add there, but that one is a quick and dirty way. The best way to do this, every time you have a meeting with your board or shareholders or whatever, document it, write it down so that we have proof that it actually happened.
Yeah, I would just say that this is a big next step that we're doing right now in Jump Docs, where this is a huge deal. You need to have a data room where you keep all of the original founding stuff that you've done. You need to all of the equity allocations, and then also the board meeting minutes. You need to actually show that you had those. And so we have a data room within Jump Docs that's automatically, every time a document is countersigned by two parties, it's automatically stored there so that when the VC asks for your data room, unlike me, where you hover over a crusty folder on your desktop that's just labeled data room in all caps, and then find out that half the shit is missing. Unlike me, you'll look like a pro and say like, oh no, here's when we were incorporated, and here's every quarter, all of our board meeting minutes. That's pretty crucial in that it definitely does make you look like a noob if you're not doing that. And we're trying to facilitate that as much as possible because this is definitely an area that, I don't know, it feels so, when you start a startup, you don't sign up to learn this stuff, right? You want to solve a business problem for someone. You want to get the lifestyle you want. You want to say F you to your boss, whatever it is that you want, but you don't be like, oh, I want to become an expert in corporate governance. Like that sounds like a lot of fun. This is one, I think that we're always presented this as startup founders where we're not sure, should I learn this or should I just either rush through it or outsource it? This is one you can't rush through, you can't outsource. You have to just say, I guess I'm going to become an expert in this. And so you've got to learn this one for sure. And so far, by the way, if you're keeping score, we're 5 for 5 mistakes that I've made. And I'm still alive, which that's nice, but I spend a lot of money to stay alive in the process. So, all right. So next up, I'll cover this one. Number 4, hiring a lawyer without startup expertise. And guess what? I definitely did this one. I hired a family friend who is a lawyer, and he was 25. That's got to go well, right? No, he had no startup experience, but was really excited about learning about startups. So guess what? We were his first learning experience. And so when I was negotiating there's like a pre-seed round, I think it was like $800K on Christmas Eve, after maybe 2 weeks of going back and forth with the investment group's lawyer and my lawyer. Finally, I had to pull the ripcord and say, we're all going to get in a room. This is a very expensive meeting. And we sat in a room for 6 hours only to find out that he had the wrong version of the documents. And so we finally got to signatures and he had the wrong version and we had to start over. That's actually probably fairly, of all the decisions that he made or that I made with him, because it really, at the end of the day, was my fault. That was probably one of the cheaper ones compared to structural stuff. Like my first round of angel investment was all common stock. And so with a priced round of common stock with 50 different friends and family investors who I then watched slowly get crushed by every VC that joined in every subsequent round. So when I got my exit, I got to give my dad, who was an investor, a perfect 0% return. Like he lost everything. Because of the structural decisions that we made as recommended by the family friend lawyer. Meanwhile, other folks made a hefty return, and that didn't feel good. You have to hire a lawyer with a startup expertise. So the question is, how do you know, right? Number one is referrals. Go to other founders and say, who should I have as my lawyer, right? They have the list. I mean, especially if you're going to go regional, which I would recommend going regional, just because they're going to know a little bit more of the specifics of your situation being in here. I had Thompson Hine. There are a handful of other law firms you can talk to, but I think it's like you want to talk to other founders, or talk to like HCDC or Centrifuge. There's a list of people who have specific practices here, who know these documents, and frankly, Lindsay knows half the lawyers she's going to be negotiating against. That's the cool thing. If it's startup specific, they already have these longstanding relationships that they already have believability. And so it makes all of the processes go faster and cheaper, not to mention that the actual decisions they make are better. If you have any doubt as to whether this person is a startup, a great question to ask. How many startups are you working with currently, right? If that number is like if the firm's number is less than 25, you're runaway. Ideally, it's over 100, right? Like these people, they can work with a lot of different startups, and that's a sign that this is the right fit for you. Lindsay, I don't know if you want to weigh in on that.
Yeah, I mean, I will tell you, people who are startup lawyers can sniff out really quickly if the other side is not a startup lawyer, and they will take you to the cleaners. Like when I know someone's not a startup attorney, like I want to be fair, but if I'm representing investor that day, it's probably not going to go great for the startup. And so you have to be so careful. So to Blake's point, make sure that, the folks are representing lots and lots of startups, and they've had a lot of what I call laps around the track. So cool. Why don't we go into the next one? So the cost of these advisors is too damn high. I would say there's one thing that I see so many startups doing, and this is like business and law all combined into one mega statement right now, but having way too many cooks in the kitchen and way too many advisors. So I will tell you, lots of people want to say that they're an advisor to startups. 90% of them have no business advising startups in any way, shape, or form. They certainly shouldn't be given equity on your cap table for doing things that they're not an expert in. So if you are taking on advisors, make sure those advisors have some sort of material experience. They've been a founder before. Okay, so maybe that's the case. They've worked with startups or invested in startups before. They're a subject matter expert in the space that you are in, or they have super strong connectivity to future investors or future customers. If any of those statements is not true, you should not be bringing this person on as an advisor. You are not only wasting possibly equity and money, but your time. One of your hours as an entrepreneur is worth like 10 hours of a normal human being's time. And so you need to keep that in the back of your mind as you're spending your personal resource of time talking to all of these people. Also, 90% of these people are giving you the wrong advice and telling you to like move your deck chairs around on the back of your patio, and they have no business doing it. So make sure that you are seeking advice from people who have done it and actually know what they're talking about, and most importantly, truly add value and are not just trying to buffer and build their personal resume or LinkedIn. Blake, anything to add?
I think that often we think that maybe an advisor slide on our pitch deck is going to make the difference, right? So if I have, this amazing entrepreneur as listed on as one of my advisors, then maybe that will be social signaling that I'm more investable. VCs are not very impressed by your advisor slide. Board member maybe, or co-founder definitely, but advisor not really, because it's a cheap thing. It can mean whatever you want it to mean. So I would say when in doubt, most people just want to help you because most humans like to be helpful. And so I would use that first. And then it's when you need actual work from people, that's when you make them an advisor. And then you list out clearly what the work is, and you give them equity slowly over the course of several years because of that. A FAST is a good agreement to look at for that. It's an acronym. don't actually remember what it stands for, but that's what most folks will use. And it even gives you like basis point targets of what you should expect based on hours spent and that sort of thing. All right. Next up, oh, this is a great one. By the way, we're 8 for 8 for ones.
Hey, Blake,
Yeah.
I just want to add one thing real fast on that last slide.
Yeah.
So kind of just two quick tidbits. First, I've seen a company that actually used this as incentive to drive to profitability. They were going on a path of continuing to seek out further and further investment rounds. And because they had too many wrong advisors, there were some covenants within their agreements that effectively allowed them to whittle down the number of advisors they had if they achieved profitability. And it became a huge incentive because the number of cooks, to your point, was too many. So it actually became a good way to like help them focus even further and help the business in the long haul. And then second, I've just from seeing kind of that point that you all made as it relates to your time, right? Everybody on the line, like your time is so valuable. And oftentimes I can see, not with those in the line, but some people that I've worked with where they want to go and get the advice of like 10 different types of organizations, even within the startup Cincy community. And the question that should be asked oftentimes is like, well, hey, what's the key one that I might want to work with? And are they capable of taking it to the next level versus kind of sprinkling it across many, because you're going to spend more time, you know, running around with your head cut off, trying to do too many things. So anyway.
It's great. Really great. All right, we're getting close. Number 2, running fast and loose with equity / the cap table. And I'll put this, I mean, I think I've already kind of given my story on that. I definitely, I had both a cap table that was in an Excel spreadsheet with mathematical errors, but more importantly, it had 60 people, all with different terms. That kind of led to that. If I were to say there's a root problem here, I would say it's underfunding your company. That's really what ends up causing this. And so this idea of like always be fundraising is a phrase that people hear and they think, oh, so I should literally always be collecting checks. That is not what that means. Always be fundraising is like maybe always be maintaining relationships with people who can connect you to VCs or with VCs themselves. That makes sense to me. But the idea of like collecting checks of 50 or 100 or 200 to buy you a couple more months and kind of always doing that was something that I did. I'd say that many in kind of like the Brandery era of startups in Cincinnati, I'd say had the similar thing where at times raising money month to month, it's a massive distraction and it creates complexity upon complexity that is extremely expensive to unwind. It signals to future investors that this is a sinking ship. And it's not good for your relationships or your health, frankly. So I'd say one of the most dangerous things you can give a founder is a document that they don't need to check with their lawyer to go and mess with the cap table. So give me a safe or a convertible note, and then I'm going to play around with it, change the terms, and then just start collecting checks. Although it felt great getting those checks, it was at times I was collecting checks that I essentially spent all of that money on having to fix it legally later. So review it with every time you raise money, review it with your lawyer. And if you're like, oh, well, this is going to be too large a chunk of the money that I'm raising, then that probably means that you're not raising enough money. You're just stringing yourself along. I think I beat that dead horse. Lindsay, anything there?
No, I think that you nailed that one. So unless there's any questions, I'll flip over to the next one.
Bring us home.
I'm gonna take it on home. So, and I'm not saying this because I'm a lawyer. Like I wear a lot of business hats too. I own like 10 businesses myself, right? Like I am telling you this because I actually genuinely care about how you move your ball forward. I see a lot of people who just look at their legal stuff as an expense. They look at it as a pain. They look at it as like, oh, I don't want to, call and ask for advice. I'm just going to try to make whatever decisions I can on my own and not understand the consequences. When really they should be looking at their attorney as an asset or a true advisor or someone who can be really helpful in helping them to guide their ship. yes, it costs money, but you know, if you're not paying for something, you're getting what that's worth a lot of times. Okay. So keep that in the back of your mind, but think about your attorney as a true asset as instead of a liability, and treat it as a partnership, right? Like if you're respectful to them, they're respectful to you. They want to work with you. They want to help you. You know, this isn't just a monetary transaction for them. They actually do oftentimes care about, you know, you being successful. And so take advantage of that and try to make sure that you establish a relationship with someone who you really, really trust. And if you find yourself having conversations and you're not trusting the person or you're not trusting their advice, I would tell you, you have the wrong person and you should call someone else. There's lots of attorneys, okay? And it's not that difficult to change over, no matter what someone tells you or whatever. It's not. Like, we have a legal obligation to provide your documentation if someone requests it because you decide that you want to move somewhere else. It's not my documentation, it's yours. So if you come to me and you say, Lindsay, I want to move to someone else, cool. Like, I will be helpful to you and I will wish you all the best and I want to see you be successful. And that's how everyone should be. But anyway, Blake, maybe you have some comments there before we turn it to Q&A.
Yeah, this is a harder one for you to say, probably just because you are the lawyer. But I'll say this: Jump Docs essentially makes it cheaper for startups to work with a law firm like Thompson Hine, right? Essentially, it means that Thompson Hine is collecting less cash from early stage startups. And it's like, why on earth would they want to do that? And the answer is because they are not trying to make their money on early stage startups. Thompson Hine's startup practice makes money when there's an exit, a massive funding round, or litigation. And essentially the early stage startups, the reason they chose this practice is because they like working with people like you, or they like seeing you have life-changing financial outcomes. And so without fail, I have a presentation that I walk. I've talked to 50 different firms in the past quarter, kind of selling Jump Docs into them. And what I found is I've not met one lawyer yet who likes charging their billable hourly rate for stuff, for repeating themselves or having to educate people. They often will not charge. They're trying to keep it as cheap as possible. And I feel like my mother bearness is coming out, but the shit that they go through from founders who think that they're trying to get ripped off. If the founders only knew how much of an opportunity they could rip them off and how little they do and how hard they're trying to make it affordable, it's unreal to me. And so I'd say watch The Godfather. If you look at the consigliere, that's what the lawyer is. It's a confidant, and you don't have a lot of those as a startup founder. Even your founders, there's certain conversations you cannot have with your founder. Then you can have those conversations or with your co-founder, but you can have those conversations with your lawyer. My last phone call as founder of Cladwell was with a partner at Thompson Hine, and it was reflecting on the years that we had together. And that's often the case. Normally, your last phone call as CEO of your company will be with your lawyer. And that was really special, and it's been a very rewarding relationship for me for years. So highly recommend it. Find somebody great. And with that, end of presentation. Any questions? That's all we got.
Hey, Blake, awesome. Lindsay, awesome. Got a question from Gabe.
Hi again, Lindsay and Blake. Thank you so much for this fantastic presentation. I love the do's and don'ts, very crystal clear. You've condensed a lot of important life learnings into a very short presentation that's highly impactful. Thank you. I am from Summit Innovation Labs. I'm the CEO. I am fortunate to have been joined by industry expert individuals that really have certain masteries in all the various areas that we need. And also, we're fortunate that we started with Thompson and Hine as a startup. So a lot of the things that you were talking about, actually we scored very well in most of them, perhaps except on one, on the first one, whether we should be an LLC or a C Corp. That was a good discussion with David Wilbrand at that time. Somehow we ended up with LLC. We're still at the early stage. We just start getting out to a test market with our product. Our organization is small. We've not hired any people. the partners are there, all of them working full time. The effort that we needed kind of got us through contracting people and paying them cash. So if we, but in the coming year, we'll be looking for bigger investments so we can really scale up and do other things as well. So what's your thinking, Lindsay, in terms of us going from LLC to S Corp? Since we are at the very early stage, what are we really looking at? Is this going to be one of those mega projects to do, or it's going to be still manageable to do?
Yeah, great question. So I'd have to take a look at just sort of, your cap table and things like that, just to confirm there's nothing like too messy going on. So if you were going to convert and you are going to take on investment dollars.
Our cap table is very clean. So the founders and few advisors will be given few shares.
Sure.
But, they're pretty clear. And your organization reviewed it. It's pretty simple.
Good. Yeah. So assuming that to be true, and assuming there's nothing wonky in any contracts that you have with any external parties, things of that nature, you're probably looking at a pretty straightforward conversion. It's probably something along the lines of like a $7,500 to $10,000 transaction. We do have fixed costs for this. Like we try to, if it fits into a bucket, which it sounds like yours might, we do have fixed costs for stuff like that. So if we do catch someone who's a little earlier, like yourself, and we can say, okay, like we can convert this, like it's not going to be too terribly painful. That is probably the range that you're looking at. Now, I will caveat that with saying, if you are going to take on institutional capital, one of the things that they will say as a condition precedent to your closing is that you need to be converted to a C Corp. So you don't need to necessarily like pay someone today to convert it to the C Corp. You can pay your lawyer with some of the monies that the investors give you as all part of like one big transaction, be it the conversion, which happens immediately prior to the funding coming in. So usually that's how it works. So I would say, like, if I was you, I'd probably think about it that way and doing it that way, and just kind of budget like, hey, an extra 7,500 to 10K for legal to make the conversion happen. And maybe it's less than that. That's always a possibility too, but knowing what I know from what you just said.
Got it. Thank you very much.
The two tough ones are if you've lost a co-founder or if you take an investment. Those two elements will make it more complex for you to convert from LLC to C Corp. As long as you have all the original partners in the LLC and you haven't taken an investment, those are the two ones that I think make it the most complex.
Yeah.
Yes, thank you very much. I think the only investment we've taken is convertible debt from one person. That's all.
Yeah. Cool.
Thank you very much.
Yeah.
All right. Well, other questions? Thanks. Let's go off of mute and ask a question.
We just covered the material so well. There are no questions.
You did. It was a great job.
You were just that all encompassing.
Tons of data, but I love the strategy that you connect in with it, right? Because I've made a few of these mistakes outside of big company mistakes, but like within my own enterprises with other potential co-founders, and the IP was a huge one in terms of we had been creating the actual like trademark and then the assets that were going to fund a coffee roasting company, where we got into a disagreement as it related to like who owned the IP, right? And that actually caused a few of us to say, well, wait, we don't really want to work together. And so because of those things, and I would say that also just a further comment off of my own experience that fits with this is that having that, Blake, you said that at the end, having that relationship and looking at the relationship with your attorney as like not just the company, but also for yourself is key, because that's where we actually got into disagreements as it related to like voting rights and ownership of the company, where, you know, hey, I trust these guys, I trust everybody involved here, but at the end of the day, right, it happens every day. There's hundreds, if not thousands, of entrepreneurs that make mistakes like these. And I love that you're tackling how to like make these avoidable. And I'm really, really excited that you all decided to join us today to provide your insight. So
Yeah,
any other
happy New
questions
Year.
that people have?
So some of the things that I've learned by working as a coach here at HCDC is what happens, especially at the college level, where a number of college buddies will get together and start a company, and they really don't do it based on what skill sets people have. And then they just give everybody the same equity. And then one person goes in and ends up doing 80% of the work, while the others still have the same amount of equity. And it could be very costly to break that up later on. So it's good to like alert startups coming out of universities to make sure they understand that. And when I taught at UC entrepreneurship, I stressed that with them as well.
So to that end, a quick question that just sprung to mind for me is, let's say you've got, you know, a few co-founders that have created a company, right? And this probably fit within a few of those top 10 tips, but they created an ownership structure. Let's say they said, hey, you know what? They created an ownership structure that was 55-45 or something like that, right? There's clear decision-making rights, and the person that has, you know, the majority equity or clear, quote unquote, right? And the person that's 45 though is working more, right? How do you manage situations like that where you may have an imbalance, so to speak, that's in the benefit of the company potentially to like make decisions, but maybe not for the benefit of the company in terms of how work's getting created and getting done and advancing the company? Is there any tips you have on managing those types of scenarios?
Yeah, I mean, so one thing people always know about me is I'm a super direct communicator. So when there's a problem, I think the biggest thing that the two founders should do is they should have a conversation and say, hey, look, there is a direct imbalance here. We need to figure out how to make this fair. So I don't think that's necessarily something that has to kick to legal just yet, but like the two business people should have a discussion about, how do we make this be fair and reasonable for everyone and keep the worker be incented and the 55% holder, like whatever, moderately happy? So then it comes down to, look, there's lots of ways that we can make things be so. You know, maybe the 55% holder is the person putting the money into the business, and he who has the gold gets to make the rules. And that's just how that goes sometimes. That's the golden rule, in case you've never heard it, right? And so that might be the thing. And then we've got to work around that. In the alternative, you know, if the worker B, the 45% holder, is saying, hey, this is patently unfair, and, you know, 55% holder, you're not doing anything. You know, I would look at, hey, does that person, is all of that equity vested? Can there be an argument to be had that maybe we can pull some of it back? Secondarily, maybe there's an option pool that can be put into place to more properly incent 45% holder to do more work and feel the benefit of that. Alternatively, you could create a structure where maybe 45% holder gets a certain amount of money back before 55% holder gets a certain amount of money back, or any participation in any distribution proceeds. So there's always a lot of creative ways to, you know, split the pie up. It's just a matter of, you've got to have that conversation with that person, because what you don't want to do is have it fester, and then it keeps going and going and going, and before you know it, you hate each other, and now we're into a dissolution place because we can't figure out how to work that through.
What's your advice on compensation or percent equity for advisors, if any?
Yeah. I mean, I don't know, Lindsay, if you, I feel like the FAST is great in that there actually are kind of industry common equity that you should get based on effort. So the big thing with an advisor is you don't give them equity up front ever. It should always vest over a period of time and have some sort of cliff. So it's only if they are giving measurable contribution over time, and you can stop that relationship whenever it's like, oh, we're actually not getting what we thought we were going to get out of this advisorship. You want to be able to have an end date so that it stops vesting. And vesting obviously is the spreading out of equity. So at some point, with whether it's co-founders or with employees or with advisors, when you make an agreement, you can say you get 25%, but in reality, that 25% is spread over 4 years. And in year one, if you quit or stop advising at any point in year one, you're not going to see any of the equity. It's only after year one that you get that first quarter of it. And then it kind of goes every year after that. That's probably the most important piece, is actually just making sure that you have the ability to walk away if it's not helpful. Second, in terms of, I'd say looking up, just Googling online, you can see a lot of benchmarks depending on the stage of the company on what to look for in terms of how much equity to give. Just don't let the person's offer shape your education on that. Instead, maybe let the internet give you the answer.
Thank you.
Great.
I don't know, Lindsay, if you had any additional points on that.
No, just wanted to see if there's any other questions. I think
Yeah.
that was great.
I love it. No, this has been awesome. Again, love the connection of all of them and how there were elements that kind of wove through where it just came down to really ensuring that you got the right types of advisors, that you're doing your due diligence to make sure that, that nothing stinks, right? That you feel as if you're making the right path or taking the right path with your company, and just how critical a lot of these things that might seem like simple decisions, right? Or simple things to like progress the company, are ones in which they aren't so simple, and that both of your experience, both practical and theoretical, if there's a combination of both, right, is perfect for this type of a topic. And we're really happy that you were able to join us today. So thanks a bunch.
Yeah.
So we've got it recorded. I'll provide it to you, Blake, but in the event that anybody wants to get a hold of you both, right, we would just kind of collect that, and if they reach out to us, we'll just refer them on to you. Or obviously, you might get people that were on the session reaching out to you on LinkedIn to connect in that fashion as well. Does that sound good?
Yeah, that's wonderful. I'm just dropping my email into the chat too. So if you feel so inspired to ask a legal question, that's how you can find me. Also, I'm very prevalent on the internet. So if you can't write this down, you will find my email somewhere on the internet.
Yeah, same here as well.
Cool. So a couple, just a real quick upcoming preview for everyone. We might ask Blake to come back again at some point. He's given this talk elsewhere, and we think it would be really great for you all. It's all about tips on raising investment. And so I'm probably going to come back and say, hey, Blake, would love to have you come back and talk again. The upcoming Huddle sessions that we have are, so just want to make sure everyone knows of them. Next month, we've got Clay Hood with Precision Pro Golf, and we have Jeff Class with Sense Diagnostics. They're going to talk about their growth strategies that they've been employing in their own businesses, and they're also clients of HCDC. So oftentimes we bring on, subject matter experts that are outside of HCDC, but we want you to hear from your own, counterparts as it relates to other clients at HCDC. And then in 2 months, we've got the opengrants.io is in the month of June. we've got a guy named Sadale Tervovsky, which runs an organization called, like I said, opengrants.io. And he is going to talk about their platform, because I know that connecting you to investments in the form of grants is one in which would be very helpful for people on the line to connect with. So wanted to provide that. And so until next month, we will see you then. Thanks
everybody.
again.
See y'all.
Thanks. Bye, everyone.
Thanks.